Okay, it's my privilege now to introduce the current Stockton chair at the Naval War College, Professor Jinks. He has an amazing background of assignments. He's currently he's the Stockton professor, but he is the McLean Professor of Law at the University of Texas Law School and a senior fellow at the Robert S. Strauss Center for International Security and Law at the University of Texas. His research and teaching interests include public international law, international humanitarian law, human rights law, and criminal law. It's funny to say that in the same sentence. Professor Jinks has his JD from Yale Law School, and prior to entering teaching, he clerked for the U.S. Court of Appeals for the Ninth Circuit, my personal least favorite appeals court in the United States since I worked on the Sonar litigation. He worked in the prosecutor's office at the International Criminal Tribunal for the former Yugoslavia, served as senior legal advisor at the UN, representative for South Asian Human Rights Documentation Center in India, served in the delegation of the International Service for Human Rights at the Rome Conference for establishment of the permanent ICC, and since 2006 has been a member of the U.S. Secretary of State's Advisory Committee on International Law. Please welcome Professor Jinks.
Thank you, Stacy. I'm going to talk about the law of state responsibility, as both Matt and Mike and Stacy, all three, have made clear. Issues of attribution, identification, and state responsibility are central in all these problems. Not only are the issues central in the sense that identifying the perpetrator is, in some non-trivial sense, essential, but also essential to the application, the administration of the use of force principles in Article 2.4 of the UN Charter, Article 51 of the UN Charter. As Stacy's description of the case studies in Estonia and Georgia make clear, and as was alluded to several times in the other presentations this morning, identification and attribution has proven difficult even in fairly prominent cases. And when I say difficult, that's understating the matter dramatically. There's a tremendous technical and practical problem. So in addition to the conceptual problems of defining what use of force means in the context of non-kinetic operations, in defining what an armed attack means in the context of non-kinetic attacks, we have this tremendous practical, technical problem, what to do about the fact that cyber forensics isn't as advanced, arguably, in some respects, and may, in fact, be far more difficult than the ordinary forensics that we associate with pinning responsibility on particular actors for actions taken on the international plane. What is it about the internet? What is it about cyberspace? Whatever that term may mean. What is it about this context that presents such a difficulty with respect to attribution and responsibility? It really is sort of three features of the internet. It's the relative unanimity, or I should say, the relative degree to which individuals participating in actions in cyberspace can mask their identity. There is a non-trivial capacity that participants have to mask their identity. There's also a non-trivial capacity that actors have to appropriate the identities of others through botnets and other sorts of devices. The speed of electronic communications makes this all the more difficult. So the trail that's left in the context of a cyber operation may not be a long trail and may not be long in this world. And finally, the decentralization of the network itself, the very way in which packets of information travel over the network, the way in which packets of information can be routed through the network, complicates tremendously the task of identifying and attributing actions in cyberspace, particularly when the authors of an attack don't want to be identified. So we have a problem. We can't discern in all circumstances, at least not to a fully conclusive extent, who is ultimately behind an attack, and all the more so, we're incapable of determining the motivations of those actors. What should we do? The practical problem becomes a legal problem. So why should we care? I want to mention a few things. Why is the legal issue or the complication associated with identification and attribution problematic? I'm going to offer a few reasons, but in fact, before I close, I'm going to tell you some reasons why you ought not be as concerned as you might be at the moment Part of that is because I don't have a terrifically good solution to the problem, so I'm going to minimize its significance. But up front, here are a few reasons why we might care tremendously. First, most obviously, in developing or choosing a response, it's important to know who's behind the attack. Which options will be utilized? Countermeasures, resort to criminal law, diplomatic engagement, the use of military force straight away. The very selection of a response will turn, in some important sense, on the authors of the attack, the origination of the attack. Second, the direction and scope of any response will obviously be determined by whatever our capacity may be to draw a circle around the universe of individuals, groups, and perhaps states responsible for the attacks or who have participated in the attacks. Third, arguably, the very right to act in self-defense turns on whether a state can be deemed responsible for the attack, for actions that are otherwise considered to be an armed attack. Mike made reference to this idea earlier, and I want to talk about it just a bit. Mike made reference to two ICJ opinions, and I think it's fair to say, at a minimum, that the ICJ has suggested this point twice. They've arguably made the point in even other cases, but we can say definitively that the International Court of Justice has suggested that armed attacks can only be committed by states. So the right to act in self-defense under Article 51, according to the ICJ, is a right that turns in some dispositive sense on whether or not a state can be implicated within the meaning of public international law in the attack, meaning that whether a defensive reaction, whether a resort to armed force is even an option for state officials, turns on whether some state can be deemed responsible. Terrifically tricky problem in the context of Estonia, in the context of Georgia, irrespective of whether we determine in some conclusive sense that the nature of the attacks are such that we want to classify them as an armed attack given their gravity, given their scope. We might need to clear this additional hurdle to activate the right of self-defense. Now, the recent resolution passed in Kampala by the Assembly of States Parties to the International Criminal Court Treaty lends further credence to this point, although I don't want to suggest that it's dispositive, but it is worth noting that the definition of aggression, adopted but not adopted, I mean, this is a terrifically complicated, I'm not sure what happened. The action taken in the context of the radical inaction that occurred in Kampala suggests that aggression can be committed only by persons acting on behalf of a state. So an act of aggression means irreducibly action taken that qualifies as an act of aggression within the meaning of public international law. Actions taken by non-state groups that aren't attributable to a state simply aren't acts of aggression within the meaning of public international law, according to the International Criminal Court Treaty, or what may become a part of the International Criminal Court Treaty. An odd formulation in many respects, making the crime of aggression different from all the other crimes in the statute, requiring state action, and that the action be taken on behalf of a state, wielding state power. Now, all of that suggests that identifying a state responsible for a cyber attack, otherwise properly classified as an armed attack, is crucial to determining whether the defending state has a right to act in self-defense under the UN Charter. However, like Mike, I think the view is just simply wrong. It's simply unsustainable. The text of Article 51 does not make reference to an armed attack committed by a state, importantly different from the text of Article 2.4, which makes absolutely plain that it's actions of states that amount to uses of force or threats of force within the meaning of the UN Charter, and acts that are directed against states. The right to act in self-defense is triggered by an armed attack without any mention of the author, the kind of entity engaging in that action. History suggests, the Caroline case, other historical precedents, suggesting that states have in the past resorted to use of armed force to meet threats posed by non-state groups, acting in what we would now call self-defense under the UN Charter. And finally, I think state practice after 9/11 has made quite clear and it's not simply state practice, it's also international organization practice, the practice of the UN Security Council. I think we have manifest evidence now that the international community, Security Council, states, NATO, a whole host of international organizations and individual states acting on the assumption that actions taken by a private armed group can amount to an armed attack within the meaning of Article 51. Now, the scope and content of a lawful response under Article 51 may remain controversial. I don't want to suggest that each and every action taken in the name of self-defense against al-Qaeda is now endorsed by a broad consensus in the public international law community. It's not my point. My point is simply that the idea of responding to an attack launched by a private armed group no longer seems to be controversial in the practice of states, in the practice of international organizations, other than this analysis in the International Court of Justice and the definition of aggression recently adopted by the Assembly of States Parties. I don't think it's sustainable to suggest that only actions taken on behalf of a state or attributable to a state can be classified as an armed attack. Now, you might think that resolves the problem in some non-trivial sense. In fact, you might think that it makes the problem largely disappear. It doesn't, for the very reason that Mike mentioned. Even if states have the right to use force in response to an attack launched by a non-state group, let's say, in fact, it was some organized group of hacktivists or some organized group of patriotic hackers that launched the attacks, that launched the distributed denial of service attacks in Estonia. If some defensive action is going to be taken under Article 51, that action is going to have to take place on the territory of some state. In other words, the military action that is targeting the non-state group will necessarily impinge, or at least when it implicates the UN Charter, it will necessarily impinge on the sovereignty of another state. We'll need a solution to the state responsibility question. Now, one easy way to resolve that problem is to develop a standard of proof and a substantive standard of liability or responsibility that makes clear when states in those circumstances are responsible within the meaning of public international law for the acts of non-state groups. That's one way to solve the problem. And the majority of my discussion will focus on the various standards that have been suggested by international authorities, the various approaches that have been suggested with respect to the burden of proof question alluded to by Mike in his opening remarks. But I want you to keep in mind, and I will reiterate at the close of my remarks, this manipulation of the law of state responsibility is only one way of addressing this problem. We might redefine the substance of states, the primary obligations of states. As Mike was suggesting in his speech, it may well be that states have an affirmative obligation to an attacked state to cooperate with that state in putting down or defeating a threat that would otherwise trigger the right of that state to act under Article 51. And the failure to discharge that obligation, to act in due diligence with respect to the threat that is posed to the defending state, means that the state failing to observe that obligation is itself subject to attack, perhaps, or at a minimum, subject to the intrusion on its domestic sovereignty that would occur as a result of military operations by the defending state on the territory of this now delinquent state or negligent state. One way to resolve the problem, but only one way to resolve the problem. So, what are the legal issues in particular that have been controversial in connection with this practical and technical problem? There are two kinds of legal issues. The first issue, most obvious issue, is what is the substantive standard of responsibility? What is the standard that we use to determine when states are responsible for actions taken on the international plane? The second issue, and we'll walk through various grounds on which state responsibility can be established in at least non-controversial grounds on which state responsibility can be established. The second issue is the standard of proof. And this is important in the cyber context because of the technical complications associated with cyber forensics. So by what metric must we establish that a state is responsible within the meaning of whatever we consider to be the most appropriate substantive standard? It's important to take these two questions separately, in part because I think we have a fairly robust body of law on one question and almost no law on the other question, but I also think it's important because if we keep the issues distinct, it will make clearer what our options are as we move forward, what our regime design options are as we move forward. So, first issue. Substantive responsibility. What is the standard? What are the standards of establishing state responsibility? So the most obvious basis for establishing the responsibility of a state is to establish that actions are taken pursuant to a state policy, pursuant to some national law. That is to say, the government as a whole has taken the decision to engage in some action. Derivative of this point is that when individuals act as agents of the state, pursuant to some authorization to exercise public authority, and they act within the scope of that authorization, those actions are also directly considered to be actions of the state. They are actions for which the state is responsible. Now, none of that is controversial. None of that should be surprising, right? Those aren't even issues of establishing responsibility in any kind of attenuated way. Those are really just descriptions of what amounts to an act of state. But now it gets more complicated. So other grounds for establishing state responsibility, even in the absence of action taken pursuant to a policy or action taken pursuant to some authorization of an agent to engage in some conduct. The first is that states might direct or instruct individuals to engage in some action. This is has not only been recognized by the jurisprudence of the International Court of Justice, but also recognized by the International Law Commission in its articles on state responsibility. Where a state directs individuals to engage in certain kinds of conduct or provides them instruction to engage in certain kinds of conduct, the state is responsible for those actions. Interestingly enough, the ILC lists as one of the primary examples of this kind of state responsibility the use of private military contractors by national militaries. The second basis for attributing, in a more attenuated way, the actions of ostensibly private individuals to the state is this notion of control. In circumstances in which the state exercises control over individuals, control of some degree, the actions of these ostensibly private groups may be attributed to the state. Now, this is where most of the action is in debates about cyber. In fact, I've just returned from a week-long conference in Estonia. There was an entire panel on the issue of state responsibility, and the primary issue in the panel is whether these standards of control in public international law are up to the task in the cyber context. So this is where much of the action is. It is far and away the basis of state responsibility on which we have the most law. We have the most jurisprudence, the most secondary commentary. There are, in the conventional formulation, two approaches to this idea of control. What degree of control must be established in order to attribute actions of a private individual to a private actor to the state? There's the notion of effective control, recognized as a basis for state responsibility by the ICJ in the Nicaragua case, referenced earlier by Mike. The idea here is that in circumstances in which the state in question actually exercises effective control over the operations of the private armed group, let's say, or the private group, is directly involved in and controls the actions of the group that give rise to the alleged illegality, here an armed attack or a use of force. If that degree of control is exercised, then the state is responsible, even if the trigger puller, the button pusher, is a private actor, an individual participating in a private group or private organization. Now, that's a high bar obviously. The provision of material support could never establish alone the existence of effective control. Even the participation in operational planning, even the participation in the selection of targets might not suffice. The point is, it must be established that the state is in effect acting through the private group, because the group is beholden to the state. The state exercises effective control over the group. The second option is the idea of overall control. This is the formulation of the ICTY in the Tadic case. This is a slight but important relaxation of the effective control test. The overall control test suggests that, of course, states are responsible, or action ought to be deemed to be state action in circumstances in which states exercise effective control over groups, but some measure of control that falls short of effective control ought also be sufficient. So where states participate in operational planning, for example, that ought to be considered a sufficient degree of control, or perhaps a sufficient degree of participation in the execution of actual operations, that the conduct in those operations ought to be considered public action, the actions of the state. Now, notice, even though we have some relaxation of the extremely demanding effective control test, we still have a test that seems to reject any notion that the provision of material support, no matter how robust, would alone suffice to establish an adequate level of control. When the International Law Commission took up the task of articulating rules of state responsibility, it was thought that the Commission would choose which standard is most appropriate in some generally applicable way in public international law. So when the ILC announced the rules on state responsibility, it was hoped in many quarters, thought in many quarters, that the ILC formulation would either be effective control or overall control. Well, the ILC instead adopted the formulation of control. And in the commentary accompanying Article 8 that articulates this standard, the ILC says there are two perfectly sensible approaches to this idea of control. Effective control, which is extremely exacting and demanding, and the idea of overall control embraced by the ICTY, which is less demanding, but nevertheless perhaps appropriate in certain circumstances. In other words, the ILC punted on which standard as between these two is the most appropriate. But it was pretty obvious in the commentary, and in fact, somewhat obvious from the very text of Article 8 on the draft Articles of State Responsibility, that the ILC thought some measure of control within the meaning of one of these two tests was appropriate, and the bare provision of material support would be inadequate. A separate ground, now moving outside the realm of control, wholly separate from control. There's an alternative basis for establishing state responsibility. There are two more that I want to discuss. This separate ground is the idea of acknowledgement and adoption of the actions of a private group. This idea traces most recently to the Tehran hostages case in the ICJ, where the ICJ recognized that the formal endorsement of the occupation of the embassy by the Iranian government and the acquiescence to, or really the absence of any effort by the Iranian government to secure the embassy ex post or ex ante, suggested that the international illegality had been acknowledged, it had been noted, and it had been adopted by the state as its own action. In other words, the actions of a private group had been embraced by the state in question to such an extent that the state had, in effect, made those private actions their own actions. Now, some suggest that this basis for establishing state responsibility is a broad idea. I mean, it could, on some views, sweep in a fairly broad number of cases. We might imagine it as a useful standard in the Estonian case study, for example. You might think the Russian conduct after the fact strongly suggested that the Russian government had no interest whatsoever in policing its own or doing anything to determine whether or not individuals on their territory were participating in the attacks, and that they had in fact made a sufficient number of public statements, and indeed some private diplomatic statements, in private to the Estonian government, to suggest that they endorsed the ongoing cyber attacks. Now, if we view this standard in a fairly broad way, it might do some work in some cyber case studies. But it's pretty plain to me, and it's pretty plain to the majority of commentators, that this standard is actually exceedingly narrow. This may be one of those examples of a standard in law that really is only applicable on the facts in which the standard was first generated. The standard is not commonly invoked by the ICJ, although one might imagine that it would be very commonly invoked. It is, in fact, rarely even mentioned. It's the ugly stepchild of ICJ jurisprudence on state responsibility. I suggest that it's narrow because I don't think that it's an end run around the problem. I think we're left with the difficulty of establishing either that states have directed private groups to engage in cyber operations that amount to an armed attack or use of force, or that states exercise some measure of control over those groups if we want to solve our big problem by reference to state responsibility. Final basis for establishing state responsibility is the issue that Mike mentioned about the law after 9/11. Did the law of state responsibility change, particularly in the use of force context, particularly in the armed attack context, after 9/11? The case for suggesting so is strong, and Mike summarized the case perfectly. One way of understanding the argument made by the U.S. and others regarding Afghanistan's responsibility, or the Taliban's responsibility for the actions of al-Qaeda, is that the Taliban supported, harbored al-Qaeda, and that was sufficient. Harboring or support of a group engaging in this particular kind of internationally wrongful act, a use of force or an armed attack, was sufficient to make the state responsible within the meaning of public international law, and to activate the right of the defending state or states to respond with military force not only against the private armed group, but against the state responsible for the actions of the private armed group. I think it's a fair understanding, it's a plausible understanding of the position put forward by the United States and others. I don't think, though, that it's a sensible, ultimately sensible way of understanding the response put forward by the U.S. I think a better way to understand the position put forward by the U.S. is that, and others, is that there was an affirmative obligation. This issue is also alluded to by Mike, but I want to make clear that we really are looking at options for dealing with the problem. That the Taliban had an affirmative obligation at a minimum in the wake of the attacks, perhaps an obligation activated much earlier than the attacks of 9/11. But at some point in time, no later than the attacks of 9/11, the Taliban government had an affirmative obligation to assist the United States and other relevant states in ending the threat, neutralizing the threat posed by al-Qaeda. The refusal to do so, or, and this is an important point, or the inability to do so, would put the Taliban in a position in international law which would, in effect, deprive them of any claim to national sovereignty, any claim to protection by the non-intervention principle, any claim to protection by Article 2.4 of the UN Charter against a use of force by the United States and other states to neutralize the threat posed by al-Qaeda. Two ways of conceptualizing the issue. We can either think the harboring or supporting idea, tolerating idea, is a new basis, a very expansive basis for attributing the acts of private groups to states as a matter of state responsibility in international law, or we can think of it as the articulation of a perfectly sensible affirmative obligation that is a condition of asserting the right, the rights that are protected by the non-intervention principle and the prohibition on the use or threat of force under Article 2 of the UN Charter. So those are the options. What strategies do we have for dealing with these problems? The problems seem intractable. The standards that are put forward in international, the substantive standards, seem unworkable. They demand a level of proof that simply cannot be established in international law. This is complicated even further by the fact that what we know, what we have established in public international law about the standard of proof necessary to establish any of these standards strongly suggests that it ain't going to be easy to prove whichever of the standards we think is the most appropriate standard. So there are various formulations. Mike, I think, makes a compelling case for embracing the clear and convincing evidence, clear and compelling evidence standard put forward by the United States in the U.S. defense of its right to act in self-defense under Article 51. Fair enough, but that's a fairly high standard. Other standards that have been expressly recognized as the relevant standard. Obviously, the ICTY suggested that beyond a reasonable doubt was the appropriate standard anytime individual criminal responsibility was the issue. And naturally, in the Tadic case, that's precisely what was at issue. The ICJ has suggested in the Serbia genocide case that what's required is fully conclusive evidence. Whatever that might mean, that almost suggests something beyond a reasonable doubt. We are beyond any shadow of an unreasonable doubt. I think we can infer the existence of perhaps the most obvious evidentiary standard, which is preponderance of the evidence standard, or balance of the probabilities standard, which may well be the most appropriate approach here. But it's important to note we don't have many public authorities expressly recognizing this standard as the standard for establishing state responsibility. And even if we accepted it as the relevant standard by which to judge whether a state is responsible, it's a high standard. It may well be that what states need in order to respond effectively to cyber threats is a relaxed evidentiary standard, one that would take account of the very real constraints that states face with respect to cyber forensics. Once again, what do we do about these problems? A multi-layered, complex problem of a pending state responsibility. There are three kinds of strategies we might employ. Fairly obvious, but worth underscoring. The first is we could manipulate or clarify the substantive standard of liability. We might say, look, control means overall control, maybe even something less than control. State responsibility is established by simply supporting or the provision of material support. State responsibility is established by the fact that an internationally wrongful act emanates from the territory of a state. There are a whole host of options that we might have, from the very demanding to the almost breathtakingly relaxed approach to the grounds on which we establish that a state is responsible. Some, notice, would also solve the burden of proof problem, at least to a non-trivial extent. If we were to push the standard all the way out to any internationally wrongful act emanating from the territory of a state, we'd be in business in most cases. Second sort of strategy we might employ is to manipulate the standard of proof. And this idea is in fact put forward increasingly in cybersecurity circles. That what's needed in public international law as it applies to cyber attacks is a relaxation of the burden of proof. Maybe all we need is something that suggests a reasonable basis to believe, ... A reasonable basis to for thinking that, ... Some evidence, quote unquote. We can imagine formulations that might be appropriate were we interested in driving down the standard of proof. Notice that both of these strategies, manipulating the substantive standard of liability, manipulating the level of proof that needs to be met in order to establish that standard, both approaches create substantial collateral costs. They generate substantial collateral costs. they both invite systematic over-application and under-application of state responsibility. We're designing a solution to a very particular problem that's likely to create difficulties in a whole host of other contexts and likely to create difficulties even in the context of the cyber issue. Remember that the majority of cyber attacks or actions that are considered to be cyber attacks on the international plane emanate, at least in part, from U.S. territory. Right? So there are very real limits that we would want to observe on what kind of approach we might take. The third kind of approach that we might take, and this is the approach that I suggest we should take, and I'm anxious to get your feedback and the feedback from the other panelists on this. I think the preferable approach is to try the best we can to forge an international consensus, whether it be through a new treaty instrument or simply through the evolving practice of states, generate some agreement on the scope of primary state obligations to assist attack states in neutralizing threats, in prosecuting individuals who are responsible for engaging in actions that are considered to be a use of force, a violation of the non-intervention principle, perhaps only a cybercrime within the meaning of domestic law, some robust conception of an obligation to engage in transnational judicial assistance. It is an end run around the state responsibility question. I recognize, I'm cheating in some ways. See a problem that's intractable? Poof, let's make it disappear. But this is a very real option in this context. In fact, with respect to almost every area of public international law in which state responsibility is an issue, there are obvious regime design questions and obvious regime design choices that reflect a consensus to regulate via first order primary rules of conduct and second order rules that determine when states are responsible for the actions of other states, when states are responsible for the actions of private actors. I think the preferable approach is to sort of try to forge agreement on those obligations and make clear not only the scope and content of the obligations, but what consequences ought to follow from breach of those obligations. If it is that the state in question forfeits its right to advance sovereignty-based claims under Article 2.4 or Article 2.7 of the UN Charter, that ought to be made express. That kind of solution in a new cyber warfare treaty instrument would, in my view, be the best approach to the kind of problems, the family of technical, practical problems presented in the state responsibility context. Thanks.
Can you turn the slides on, please? Can you turn the back on so I can see as well? Can you turn the back? Thanks. All right, as Stacy said, we're going to shift gears here in a huge way. We've been talking so far about the jus ad bellum. We're going to now talk about the jus in bello. In other words, law of armed conflict, or as we call it in Europe, international humanitarian law, and ask how that applies to cyber operations. Now, the case study I'll be using, bear with me if I see if this, yeah, great. The case study I'll be using is not Estonia, which we've heard about, but rather Georgia, and Stacy has briefly alluded to Georgia. Let me give you some of the relevant facts, at least relevant facts in the jus in bello context. There was a war. It was an international armed conflict between Russia and Georgia. It lasted roughly a week or so. During that conflict, there were extended cyber operations conducted from Russia. In fact, there were sites that were set up in Russia that contained hacker tools, and there were extensive target lists on these websites. So you could go onto a Russian website, a website based in Russia, and you could gather the tools you need to hack into some Georgian site, and then you could know who to attack. For example, it contained email list of everyone in Parliament. The methods were defacement. In other words, you go into a website and change it, or denial of service. In other words, you can't get on your computer and do what you had hoped to do. The targets included the government, but not only the military, but also more civilianized aspects of the government, like the Ministry of Education. The MOD and the MFA were both targets of attack. It also included civilian targets ranging from service providers to the Georgian banking system. The attacks were relatively short, on average about 2 hours per attack. The longest was 6 hours. In other words, if it was a denial of service, you were offline for not more than 6 hours. And the consequences, and this is going to be critical in the analysis, the consequences included no destruction of property and no injuries were caused as a result of the operations. Basically, Georgia could simply not get its side of the case out to the international community. Now, I will note that the Georgian banking system was brought down for 10 days, but that was not brought down by the hackers, but rather by the Georgians themselves, because they wanted to ensure that their banking system was secure. So they voluntarily shut off their own banking system for 10 days. In terms of the source of attacks, they came from Russia, but not necessarily from the Russian government. There are two pieces of evidence that would imply some Russian government involvement. The first, very interesting piece of evidence, is that within hours of the launch of kinetic operations, of actual military operations, within hours, there was a website that was established in Russia called stopgeorgia.ru that already had extensive target lists available on the website. And this was in just a couple of hours. This would suggest the Russian government may have been somehow involved, if nothing more than notifying the hackers of involvement. However, there are problems here, and Derek talked about them. They apply in the law of armed conflict as well. It does appear, after having done computer forensics, that Russian government was involved in some way, but it also appears that those sites may have been PNW'd. In other words, that the hackers actually temporarily took over the Russian government sites to conduct their attacks. In other words, they were spoofing the origin of attack. The international community came to the assistance of Georgia. Interestingly, Google provided hosting services to better withstand the attacks because Google has good defenses, and the Georgians did not have good defenses. The MOD and MFA websites were moved outside the country to the United States, to a private company in Georgia, Atlanta, Georgia, which was sympathetic to the Georgian cause, perhaps for reasons beyond their name, and to Estonia, which had, of course, suffered its own attacks from Russian hackers earlier. And then the Polish president, the one that died recently, the Polish president made available the Polish presidential website for posting of Georgian government information. Now, when we're talking about cyber in the jus in bello, there are lots and lots of issues. What I will address are just the major ones, some of which were implicated during the Georgian case. This, by the way, this picture here is a picture of what was posted on stopgeorgia.ru. These are targets that you can launch attacks against. Now, the number one issue, the major issue here is what's a lawful target of a cyber attack? And that, of course, is all about the principle of distinction, which is set forth in its broadest terms in Article 48 of the Protocol Additional, the first Protocol Additional, and which we in the United States recognize as customary international law. And there's a problem. And the problem is, if you look at the text of Article 48, you see that the prohibition is on directing military operations against other than military objectives. So this begs the question of whether or not LOAC, whether or not IHL rules out virtually all cyber military operations against anything other than a military objective. In other words, reduced to basics, can cyber operations be directed against civilian objects and the civilian population consistent with IHL, or does Article 48 rule them out? In order to answer that question, I believe we have to ask how the protocol and how humanitarian law, law of armed conflict, has generally treated the words military operations. If you read the protocol carefully, what you'll see is that the term military operations, the phrase military operations, has been operationalized in the context of the word attacks. So you have Article 41 saying no military operations against other than military objectives, but then in Article 51 it says don't conduct attacks against civilians. Article 52, don't conduct attacks against civilian objects, and as you see here on the slide, over and over and over and over again, when they're talking about military operations, virtually all the prohibitions are framed in terms of attacks, which then begs the question, okay, fine, what's an attack? Well, fortunately, the additional protocol actually defines attacks for us in a way that's acceptable to non-protocol parties. It defines attacks as acts of violence directed against the enemy, whether in offense or defense. And so you have this notion of violence now that's being fed into attacks which operationalize the concept of military operations. And you see this notion of violence over and over and over again in the law of armed conflict. You see words like dangers, violence, loss of civilian life, injury to civilians, on and on and on. You can read that yourself. In fact, I would note that the ICRC commentary to Article 48, which is where the term military operations apply or appears, specifically says that military operations are those operations during which violence occurs. Violence is used. And the Bota commentary, another very authoritative commentary on the protocol, equally says acts of violence, well, they mean physical force. Now we have a problem. And the problem is cyber is not violent. It involves no physical force at all. It's ones and zeros. It's bouncing electrons. But I think it's clearly accepted in international humanitarian law, law of armed conflict, that what we're really talking about are the consequences of the action. It's not whether the action is violent, but rather what the consequences are. And we know this because no one in this room is going to deny that a biological attack, which involves no kinetic force, no physical force, is an attack in the law of armed conflict, or a radiological attack. And so why should cyber be any different? What this does is this leads to the conclusion that the prohibitions on attacking protected persons and places must be understood in terms of the word attack. It's not unlawful to target them, it's unlawful to target them in a way that rises to the level of an attack, which I would define as an operation which causes death or injury to individuals or damage or destruction to objects, whether they are the target or the object of attack or whether it's caused collaterally. Because in the cyber context, you may be able to launch an attack against the lawful military objective that causes no damage or destruction to that objective. It simply shuts it off. But the consequence may be harm, physical harm to the civilian population. You have a dual-use air traffic control system, shut it down if civilians are relying upon that, and the aircraft crashes as a result. That did not cause destruction. The attack did not, but the collateral effect clearly did. So to me, that's an attack. There's a problem. Every time I talk to a wirehead about this, they say, well, data, I mean, they love data. Data is property. Well, I'm not so sure. To me, data is not an object unless that data can be immediately transferred into some tangible object. So I go to my ATM machine, I've got a bank, it's full of ones and zeros, tells me how much money I have, I put in my card, I get cash out. That's relatively simple. And in addition, in a group I'm working with Derek and Wolf and a few others, we've talked about the concept of cultural property. Because you can have cultural property in the 21st century that's entirely data. For example, a photograph. When you take a photograph, all you have today is a bunch of data. Well, what if you have photographic cultural property and it's destroyed? So if the data has value as such, I would at least argue that it is in fact an object and an attack against it which destroys it would qualify. In Georgia, there are no attacks because it's just defacement, it's just disruption. Niels, you need to tell Knut I did this. However, that's the Schmitt analysis, and there's this other guy called Knut Durham, which many of you know. He's a dear friend of mine, and Knut has written on this subject as well. You can find his piece on the ICRC website. Just type in cyber, and you'll find it. And Knut has a different approach. And what he says is this guy Schmitt's missed the boat because he forgot to read Article 52, which is about the definition of military objective. And he says the military objective definition includes neutralization that gives you some advantage. And he's right. It clearly says that. So Knut then says, well, then merely disabling is an attack. You don't have to do what Schmitt says, destroy, damage, kill, or injure. Merely disabling something is an attack. It's irrelevant whether an object is disabled through destruction or in any other way. So if we're accepting the Durham analysis, which is not unreasonable, then there were attacks that were conducted in the Georgia case against the banking system, against internet service providers, and so forth. However, since he's not here to defend himself, I get the last word. And let me explain why my dear friend is completely wrong. The reason, I forgot that this is being taped and placed on the internet. I'd like that edited out, Dennis. Let me explain why I have a slightly different opinion than the renowned jurist and commentator Newt Dorman. That's because Article 52, which is where the word neutralization is contained, is not about attacks. It's about military objectives. So the word neutralization refers to when something qualifies as a military objective, not when something qualifies as an attack. In fact, the concept of military objective is irrelevant until you first have an attack. It's only when you have an attack that you have to ask, has the attack been against a military objective? And then I would also say that although I believe Knut's opinion or approach is reasonable, I would say, well, if that is correct, then golly, what criteria do you use to distinguish those things that you cannot, those civilian things you can't attack, and those you can? Because I can, for example, mount a PSYOP against civilians. Everyone accepts the fact that's lawful. So if this is the case, then they bear the burden, or Knut bears the burden, of producing the criteria by which to distinguish those two forms of attacks on civilians. Military objectives. Let me now turn to a few related aspects of the law of targeting. We don't need to go over what a military objective is in this audience. I believe that in Georgia, the attack on the Ministry of Defense website was an attack against a military objective by nature because it is the Ministry of Defense. With regard to the other websites, I believe none of them were military objectives. It's not particularly relevant because, as I said earlier, most of them were not attacks in the first place. So the fact that they weren't military objectives isn't relevant to lawfulness because you first have to have an attack. However, with regard to the concept of military objectives, I think two things are important. The first is that the Georgia case showed us that if you go to war with cyber, what you can expect are attacks against other than military assets, non-military government assets or civilian assets. Why? Because they're softer targets. So anticipate attacks directed against what you would normally believe to be military objectives. The other thing you need to be sensitive to is the fact that the attacks in Georgia kind of clue us in that there may be attacks against objects that would qualify as war-sustaining objects, like the banking system. Now, many of you know that there's a big debate in international law over whether or not war-sustaining objects qualify as military objectives. Certainly NWP 1 TAC 14 Mike says they do. I anticipate the new Joint Service Manual will say the same. Many people say they do not. The ICRC says they do not. Mike Schmitt, for what it's worth, says they do not. However, in the cyber context, this issue is going to raise its head because many war-sustaining objects are vulnerable to cyber attack. So stay tuned to that issue. Proportionality, cyber plays out in an interesting way in proportionality because with cyber attacks you can have a lot less collateral damage because they can be very surgical. You're attacking IPs, you're shutting off things instead of destroying them and so forth. However, you need to be sensitive to the fact that there are going to be lots more indirect effects. And the reason is because of connectivity, interdependency, dual-use objects, and so forth. So the question is how do you deal in this networked world with these reverberating or knock-on or indirect effects? In my mind, the key issue is not the remoteness of the impact that is caused by your first cyber attack, but rather the extent to which you can reasonably foresee it. And if you can reasonably foresee an effect, no matter how far down the chain it occurs, then in my mind you must take that into calculation when conducting your article, your proportionality calculation. And precautions in attack under Article 57, and of course customary international law. Cyber is again relevant here, in particular because remember you have an obligation to verify the target. And with cyber operations, you can do a better job of that. You can use your cyber operations to verify the nature of a target that may be subject to kinetic attack. You must also be sensitive when applying the requirements to take precautions in attack to the fact that now alternative methods and means have been opened up. You attack something with cyber instead of kinetically, and different targets. You may want to attack the electrical grid that is providing electricity to your target instead of destroying the target itself. If doing so minimizes collateral damage and you're not forfeiting military advantage, and it's feasible, then you have to do it, which raises the question of should we put a wirehead into the mission planning cell. So when he's talking to the air guy who wants to drop an iron bomb on a target, the pencil neck geek wirehead over here says, you know, I think I can actually turn that target off instead of destroying it. There is an issue that will be discussed, I assume, in the UAV panel of man out of the loop. There's a man out of the loop issue here in the context of what are known as hack-back systems. You're the subject of an attack, and your computer is programmed to attack back at whoever has attacked you. I don't believe there's any legal issue with regard to who you're striking back at, because they either qualify as combatants or they qualify as direct participants in hostilities. The issue is collateral damage. When you're hacking back, how can you know what collateral damage you're going to cause? And that's a tough technical issue. However, don't blow the issue out of proportion, because remember, it's only an issue with regard to precautions in attack, is if when your hack back itself rises to the level of an attack. It's only at that point that the restriction would apply. Is cyber warfare an indiscriminate means and methods of warfare? No, it's very surgical. You attack IPs. On the other hand, it can be. You can develop a virus which is designed to spread randomly in systems, and because of connectivity, it could be very indiscriminate. However, again, don't blow this out of proportion, this problem, because it's not indiscriminate if you're conducting the attack against a closed network and then it spreads through some non-systemic means. For example, you're attacking we'll attack the Canadians. You're attacking a closed Canadian net. However, the general has a memory stick, and he sticks his memory stick into his computer at the office. A virus is downloaded into the memory stick. He goes home, he gets on his daughter's Apple computer. I assume they all have Apples. She's 15 years old. And then he spreads the virus. That does not make the attack indiscriminate, because it was into a closed net. The other thing to remember here is we're only talking about operations that will result in consequences that rise to the level of an attack. In Georgia, there were no issues with regard to that. The what? You don't have a daughter? I'm thinking of Ken Walken, who has, I think, multiple daughters. So I have daughters too, and we've shared many. In any event, what you're really here for is to look at the cat fight between the pro-direct participation guidance folks and us. And here we go. First round, Niels. There is a panel on direct participation this afternoon, but unfortunately I have to go to a meeting this afternoon, so I will miss it. So I thought I would get my blows in before I had to leave, so I apologize. Direct participation is extraordinarily relevant in the cyber context. Why? Because many of the cyber operations will be conducted by individuals who are not members of the military. They may be hacktivists. They may be patriotic hackers. They may be contractors. They will not be conducted entirely by the military. And so it's a critical issue. Remember what the rule of direct participation says. You can't attack civilians unless those civilians are directly participating in hostilities, and then only for such time as they who have a continuous combat function. Not everyone in the group, just them. So let's apply that in the cyber context. It's an organized armed group Remember, if you have an organized armed group, guys continue, the gloves are off. You can attack them anytime, any place. Can a cyber group be an organized armed group? I think so, because hackers are armed if their operations amount to attacks. I don't see why not. And the other thing is that it seems to me that even if the hackers' operations don't rise to the level of attacks, that nevertheless, if they're directed against the military, then they can qualify as being armed. And here I would turn to the concept contained in the guidance of continuous combat function. I think it's a very useful notion in the context of a group. If you have a group which has a continuous combat function, to me, that group is directly participating, and therefore that group is an armed group. But this is a new approach. I don't know if it will be accepted. May the group be organized? It's an organized armed group virtually. I think the answer is surely yes, but be careful. There has to be some coordinated activity for it to be organized. It's not just that it's acting in concert. In the Georgia case, you had the websites that said, go attack the Georgians, and a lot of people did. That's not organization, that's acting in concert. Only when they begin to work together to determine vulnerabilities, craft tools, and so forth, do you have an organized armed group. I do reject the belonging to requirement set forth in the guidance. I reject the continuous combat function. That will be talked about this afternoon. I don't want to discuss it here. And so what does that leave? Direct participants are all the hacktivists you see, the patriotic hackers, the people that take up the call to attack the evil Estonians or to attack the evil Georgians. In Georgia, I don't believe there were any organized armed groups, although there was some cooperation. They would at best be civilians who directly participate in hostilities, but to be a civilian who directly participates in hostilities, your act, your cyber act, must amount to direct participation. The interpretive guidance sets forth 3 criteria. I happen to agree with those 3 criteria, although I don't agree fully with the way that they are applied. I take a somewhat broader approach. The first criterion is that the act must reach a certain threshold of harm. In other words, it has to adversely affect the enemy, or it has to cause death, injury, or destruction to civilians and civilian properties. Classic example, cyber intelligence gathering. That's clearly direct participation. I would argue that the ICRC needs to expand that notion to include enhancing one's own capabilities, for example, identifying your cyber vulnerabilities, so has to be able to mount an effective defense. I would note, and this is, maybe Niels can address this afternoon, I would note that in the DPH guidance, the notion of death, injury, or destruction is included with regard to acts that constitute direct participation when directed against civilians, which would seem to be the appropriate standard for attack. So it seems to be a non sequitur there, not horribly relevant, but maybe that could be explained away. In Georgia, I don't believe the cyber attacks met the threshold except for the attacks on the Ministry of Defense. Now, there are 2 other criteria. Remember, the criteria are cumulative. You must meet all 3. The second is direct participation or direct causation, which requires a causal link between the harm and the act or that is in question. I find that generally acceptable, although I would broaden the notion a little bit. What I found objectionable in the guidance were the examples they used of indirect, in other words, not direct causation. And the classic one, the one that all of the folks with operational experience have fixed on, was the citation of the assembly of improvised explosive devices has not direct causation. Many people disagree with that. I happen to be one of them. And I think there are cyber analogies here. You're developing software which is designed to intrude into the enemy's system. That's a lot, because it's specific to the vulnerabilities in that system. That's a lot like building the improvised explosive device, which will be used next week on the road, just up the, so there's a degree of directness which is not present in simply creating, crafting, building munitions on a continent away. So although we all accept the notion that munitions factories are not engaged in direct participation, or the individuals that work there, we reject the notion of IEDs, and I think you can make a cyber analogy. The third requirement is belligerent nexus. I agree with the ICRC on that. I believe Georgia would meet most of these requirements, these 2 requirements, but would not meet the threshold of harm. Last thing about direct participation is the very, very contentious issue of the for such time, because remember what I told you the standard was. You can attack people who are directly participating, but only for such time as they directly participate. So what in the world does for such time mean? Well, the interpretive guidance says it's execution, that's obvious, everyone agrees, and it's deployment to and from the attack, and everyone agrees with that. But this creates what's called a revolving door. In other words, I prepare for the attack, I'm vulnerable. I attack, I'm vulnerable. I'm coming home from the attack, I'm vulnerable. But when I get home, I may not be attacked. In other words, it's a revolving door. I'm safe, and once I go out again, I may be attacked. The guidance says that that revolving door does exist, and that it's not a malfunction of IHL. I disagree. I would argue that it is a malfunction. I don't believe a revolving door exists in the law. You'll hear, I'm sure, the debate over that this afternoon. But the reason I bring it up here is because cyber illustrates the practical difficulties of the revolving door standard. So you should remember this when you move into the afternoon sessions. First, it may take a long time to identify the actual actor in a cyber attack in a way that's reliable, in a way that you know that they're not spoofing. Cyber attacks are periodic. There's no concept of deployment. You push a button, there's no deployment, you're simply pushing a button. The attacks can occur for short periods. Remember, Georgia was 2 hours. And the effects may be long delayed, and you have to ask the question, how am I going to deal with that? I put a logic bomb into an enemy system. The logic bomb doesn't go off for 4 months. Is that for such time? Is the person vulnerable throughout that period or not? How would the for such time approach, revolving door approach, apply in this case? That's unsettled. And the last thing I want to briefly mention is not strictly IHL, and we have Wolf von Heinig, who's a true expert in this, is neutrality. Remember that under Hague 5, a neutral can allow belligerent communications to pass through its country. And obviously that's relevant in the cyber context, so long as that transmission is over publicly available resources. That's a logical interpretation of law in terms of cyber. There's a problem. What if it goes beyond that? What if, for example, another country offers server space to a belligerent, which is exactly what happened in Georgia? What if another country allows non-publicly available cyber infrastructure, not military, but non-publicly available cyber infrastructure, such as the presidential website? What if another country provides cyber security services to one of the belligerents? Is this a violation of neutrality? My sense isn't that in the Georgia case there weren't a lot of military applications, belligerent applications, but I certainly believe that the movement of the MOD website, which is a military objective, into another country and providing service space for that website, not merely transit, was probably a violation of the law of neutrality. And with that, Stacy, I think we're ready for questions across the board.
Thanks, Mike, both for the great presentation and for keeping us on schedule. We have about 10 or 15 minutes before my party planner is going to boot us out of here, so please direct any questions from any of the presentations or anything else you might want to ask on this topic to any panelists or to all of them. Yes?
This question is directed to Mike. On the slide, Jared Silverman from Navy Strategic Systems Programs. This is related to the slide about man out of the loop versus the automatic hackback that you said. I would suggest that the man really isn't out of the loop who developed the software, because I think you alluded to that in the other slide about direct participation in hostilities. And I think there's historical legal precedent for getting back to the man who developed the software in the cyber example with what happened, for example, in the Nuremberg trials, where the chemists, two of the chemists who created sarin were actually prosecuted, who worked for IG Farben, with that example. So there is historical precedent for, I think, reaching back even to software development if they put in a program that would automatically hack back. I'd be interested in your comments on that.
Maybe I was misunderstood. I certainly didn't mean to suggest that man-out-of-loop systems are in any way unlawful. I'm simply wanted to identify that, because man-out-of-loop systems, I think it is a man-out-of-the-loop. We're quibbling over terminology that has no legal normative meaning. The real question in these cases is whether or not you comply with the principle of proportionality and whether you comply with the principle or the requirement to take precautions in attack. So I certainly, whether it's a UAV or a computer, I don't think man-out-of-the-loop systems are unlawful per se. You have to look at how they're applied. I certainly believe that you can have a man-out-of-the-loop system that's much more reliable than the determination made by someone on the battlefield who's being shot at, et cetera, et cetera, et cetera. So I don't think man-out-of-the-loop systems are unlawful at all. I simply was trying to point out that the problem with man-out-of-the-loop systems in the cyber context is knowing what collateral damage there is likely to be. I think in many cases you can solve that with a technical solution, okay, in the same way you can do that with a UAV. And moreover, I don't think it's an issue in most hackback operations because the hackback will seldom cause the level of harm that rises to the level of an attack or rises to the level of collateral damage, to be more precise. So I didn't mean to suggest that they're unlawful or anything like that.
Okay, what other questions? If you push the button.
Hold it on, okay. Hello, my name is Valerie Epps. I have a question, a brief comment on 2 points that Professor Schmitt made, and then I have a bigger question, I think, which is addressed to the whole panel. And first of all, I'd like to say I thought it was a great panel from all of the presenters. Thank you so much. Okay. Professor Schmitt, you had 2 references to the Nicaragua case which I find troubling and I don't agree with. You seem to say that the right of a state that is a victim of a low-leveled use of force to respond, they do not have the right to use low-level use of force back. Although, of course, that was not the issue that was addressed by the court in the Nicaragua case. I think there is a paragraph that talks about El Salvador's possible right to use countermeasures against low-level uses of force that does not rule out low-level uses of force back. Okay, although it would rule out something of a higher level use of force probably on the grounds of proportionality. Okay. Also,
can I stop you just 1 second? I'd like them to address the question immediately after you ask it, or the point.
well,
do you have a related point?
To Professor Schmitt again, and it's on the Nicaragua case. So
Okay.
Let me just do this. The Nicaragua standard for attribution, as you rightly said, they said, yeah, if your state sends armed bands across the border, et cetera, that's state action. But you basically stopped there, and you said the Nicaragua standard for attribution is gone now. But I think you're forgetting 2 words that they also use in that. They talk about or the state's substantial involvement therein. And I think that would give a much broader scope for attribution. And my big question to all of the panel is this. What are the consequences of abandoning the necessity of tracing activity back to the state if you want to authorize attacks against non-state actors? What are the consequences of not going the state attribution route, which has been the traditional route to go? And in particular, maybe Professor Waxman could talk about what this does in terms of power politics, who it favors if you abandon state attribution.
You're certainly correct, Professor Epps, with regard to the Nicaragua case and your first question. I did not even have to wait to come back here to have you ask the question. My dear friend von Heinig caught me during the break and beat on me for the same point. Of course, you're right. Of course, you're right. Of course, there is the issue in international law of whether or not countermeasures may be forceful. The International Law Commission indicates that the answer is no. But this is, you're exactly right. Nicaragua said that. This is what happens when you find out you're speaking 45 minutes. You're right. With regard to the second question, substantial involvement therein, you're certainly right there. And in fact, I would argue that the substantial involvement therein is the more important part of the standard, because it allows much more flexibility. However, the substantial involvement therein would still not cover the actions taken by the Taliban. I don't believe that the Taliban were substantially involved in the actions of al-Qaeda, because I know who you are, so I know you're familiar with all the practice. In the case of al-Qaeda Taliban, it was really the provision of sanctuary. And if you look at things like the American National Strategy for Counterterrorism and so forth of 2005, clearly everyone's thinking in terms of sanctuary. And I would argue that sanctuary does not meet the Nicaragua standard. So there is a suggestion that the standard has been lowered. Again, I don't have a firm view on this because, as I said, I don't know where the standard's been lowered to. I know that I have a sense that Nicaragua, it's lower than Nicaragua, but how low, I don't know the answer to that question. But you're exactly correct to point out the substantial involvement therein. But nevertheless, I still think states are likely to draw a lower threshold. Where? I don't know. Wolf, did you have a follow-up? Oh, I'm sorry. Wolf was raising his hand on that issue, so. I'm sorry, man.
No. If I understood your question correctly, it was what would be the consequences of requiring that self-defensive force be traced back to some state that had responsibility for initiating the threat, right? And I think the biggest concern from my perspective would be that I think such a legal regime would be underprotective of states' security in a world in which non-state actors are increasingly able to wage destructive violence globally against powerful states. In my mind, when I read opinions of the ICJ or scholarly views that believe that self-defense is only authorized against a state, so that in order to respond militarily to a non-state threat, you would have to link that threat back to some state. I think that is wishful longing to a world in which the main threats that states faced were either from other states or from violence that was territorially delimited, that was localized. I think in an era in which terrorist organizations are able to organize on a global scale, in a world in which cyber violence can be conducted with massive effect across territorial borders and by non-state actors, in my mind, such an approach is underprotective of state security.
All I would really add, I'm in agreement with Mike and Matt, but I do think we have to draw a distinction. When you say what would be the consequences of abandoning a certain kind of approach, there are two kinds of circumstances. We might ask, and this is, I think, the question that Matt's addressing most directly, what if we abandon the idea that an armed attack can only be committed by a state, or use of force can only be committed by a state? That sort of view, I think, is increasingly implausible and generates all the problems that Matt identified. The other issue, which is a related issue but an importantly different issue, is what happens, what are the consequences if we abandon the idea that we need to prove state responsibility for those attacks or uses of force if we want to use force on the territory of that state? Right? So what level of, do we need to cling to some idea that there needs to be responsibility of the target state, even if the state doesn't have any direct responsibility for the actual attack that triggered the right to use self-defense in the first place? And I'm sympathetic to that worry, but I think we can sort of maximize the protection of all the interests described by Matt while minimizing the concerns that you have if we develop a fairly robust understanding of the affirmative obligation of the territorial state to neutralize that threat. Now, On the issue of that you raised about Nicaragua and countermeasures, I do want to invite Wolf to speak to this, because Wolf, you had a terrifically helpful intervention on the point in Estonia, and I do want to refer everyone to Judge Sima's separate opinion in the oil platforms case, in which he defends quite forcefully, no person other than Bruno Sima defends the view that countermeasures may involve the use of force within the meaning of force, so long as they don't rise to an armed attack. But Wolf, I did want to, thanks.
Wolf?
Well, I won't repeat the separate opinion, but I have to ask the question whether it is really the correct approach when it comes to attributability to start with state responsibility. The draft of the ILC has been worked out with a view to an ex post facto determination of who would be liable in international relations. When it, however, comes to self-defense, countermeasures, etc., of course there are some similarities with the draft, but especially when it comes to self-defense, I couldn't care less to have a certain standard fulfilled, because the standard that counts is my self-perception of the threat I'm in, and I will react accordingly. And it's an ex ante determination, and there, of course, the criteria that must be applied in order to determine of who is the origin of the threat are much more relaxed than under the law of state responsibility. So we have to be careful not to easily hop on the draft, because that's the only thing we have in a written form so far. And that certainly is not what international law is all about. There are other criteria we can use, and I think there the speakers seem to agree to a certain extent at least. A final point. It's funny, it took us 1 decade in the 1970s until the 1980s to reject all those efforts by what you call the developing or third world countries, that not any form of coercion falls under the scope of Article 2.4. We ultimately succeeded in limiting Article 2.4 not to a prohibition of coercion, of any kind of coercion, but to the use of military force or the threat therewith, which is unlawful, ! Now, if we try now to reintroduce or to reopen that debate of the 1970s, wow, you are opening Pandora's box. Wait just 5 minutes and you have again the claims for widening it to political, economic and other threats. No, what it all boils down to, we have opened vulnerabilities by purchasing off-the-shelf, commercial off-the-shelf software, hardware, etc. And now we are complaining that there are some people out there who will exploit those vulnerabilities. I think there is no way out of that any longer, because we have already gone too far, and it would be rather impossible to introduce hardened systems that would be reserved for governmental or military purposes. So the only way out would be to, equalize the vulnerabilities by making the others as vulnerable as we are. But this does not solve the problem of non-state actors who couldn't care less whether states are vulnerable in their IT infrastructure. And that's where we have to go to. However, again, be careful, because there are people out there who support a single criminal law approach. And that single criminal law approach will, of course, have negative repercussions on the options states, of course, must preserve for their purposes. So something may be clearly illegal for an individual to do, for private ends, but certainly not for a state or a government during an armed conflict. And so if we have an agreement, what you proposed, Derek, then please reserve the official or the state part for what the states need. And cyber attacks may be an option, and we should preserve that option and not fall into the trap of a single criminal approach, which very many people advocate out there. Thanks.
Thank you. There was one more question that I think we got to, and then we're going to have to cut it off because I'm getting glares from Mike.
Commentary. I'm thinking that, you know, no, you know, I think that the main idea, my idea, is to try to forge the international law, because we are trying to stretch too much the international law relating to the armed conflict, you know, to put them in the cyber war fitting. It's too difficult that. Because, you know, we are dealing with a non-tangible war. We don't see it, in fact, you know. It's not like seeing tanks and weapons. And also, it's very hard to prove, you know, because you have to disclose your own information about your own servers. And that cannot be, as you said, it's very hard to prove that. So, just remember that we don't have only one state here. We can deal with 1, 2, 3 or more states, or even civilians that they really don't know that they are dealing with, you know, they're conducting a DOS attack against another web servers. It's very difficult, and I think that we have to rethink everything, you know, to reshape, to reforge. This is my idea, you know. Sorry for my English. This is a fifth language for me, so this was my.
I'll respond, but only to make an advertisement for a project that's underway. I happen to agree with you. It is difficult to apply the classic law designed for kinetic operations to non-kinetic operations, and that's true whether it's the jus ad bellum or the jus in bello. So the NATO Cyber Defense Center of Excellence, in cooperation with Durham University, which happens to be where I am, has launched a project to do exactly that, to craft a manual on the law of cyber warfare that addresses both ad bellum and in bello aspects, and asks questions like, does it make sense to apply the law of state responsibility in the context of cyber warfare? You know, how does perfidy apply in the context of cyber warfare? A number of people are involved. Derek is on the project. Wolf is involved on the project. There are about 20 people. They are not affiliated with states in any way, because we wanted to avoid a connection with states. Some are scholars, some are practitioners, all have some experience in military affairs, either as a Stockton professor. Ken Watkin from Canada, he used to be, I guess he used to be a JAG or something in Canada. I don't know. And we'll be producing that document over the next probably 2 years that hopefully will at least provide a perspective of a group of 20 people on what we think the appropriate application or non-application of the law is to this very bizarre thing called cyber warfare.
Okay, can you please join me in giving a round of applause to our superb panelists?